And I believe we're recording whenever this is. Not legal advice. Like, subscribe, share, translate. I usually talk about dogs, but I understand that fish really enjoy these videos also. So play it for your fish. Anyway, hope everybody is well. I was planning on doing a one video, but it ended up going too long, so I'm doing a second video. The second video is on Alpine GTII and the decision that just came down yesterday, the 6th, and by the SEC, and I wanted to address it. But of course, before I addressed that, did you hear they arrested the devil? They got him on possession. And by the way, I wonder, yeah, I thought about this. Why am I waiting? Why am I waiting for like a response? I say the joke, it's bad. There may not be any response anyway, but I'm waiting like there's going to be a response. And what is the difference between an outlaw and an in law? An outlaw is wanted. Anyway, so I wanted to talk a little bit about the decision that came down yesterday involving Alpine. Alpine is connected to GTII, it's the prime broker. We've discussed that in depth. So, some of the proceedings that we've talked about involve an appeal involving FINRA and involving the potential expulsion or expedited expulsion of Alpine by FINRA or the SEC. And that's what we've been talking about. And the appeal that we've been talking about involves those parties. The particular document that came down yesterday involved the National Securities Clearing Corporation, and they were involved in some type of litigation with Alpine. So that's separate and apart from FINRA and the SEC and doesn't directly involve any expulsion or any issues of expulsion. In other words, uh, Alpine being expelled from being able to do business. So um, the way this arose is and I'm going to say the NSCC is the clearing agent and handles clearing functions, including for microcaps and OTC, including Alpine in this case. Although it doesn't handle, I believe, and it wasn't stated, the offshore, the stuff that happened in the Caymans, because I know Hurry has his own Cayman Trading Limited, which I guess was the clearing firm for foreign transactions. So that wouldn't have been counted, by the way, in this. But in terms of, I guess, domestic clearing or sub clearing, the NSCC would do that for Alpine. And in their function and capacity as the clearing agent, they both would collect the money, and I mean, I'm simplifying, but collect the money and deliver the securities. So they were fully responsible and at risk. Because they were at risk, they collected a deposit from its members, including Alpine, and for various categories, um, illiquidity, etc. And they based the deposit on I'm going to call it the scumbaggery of the participant. So the bigger the scumbag, the bigger the risk you were, the greater the deposit you'd have to make because it'd have to be commensurate with the risk. And excuse me, and lo and behold, Alpine was deemed to be the greatest in the various categories that they had set up. Alpine was deemed to be the on the highest risk, biggest scumbag list, not shockingly. And and that was based upon not about any of the violations we talked about having a sex offender working for them, about having violations of the Bank Secrecy Act, about the 54 million misappropriations, just solely upon their business, how they were conducting their business at the time, not involving those particular elements. So they were charged a significant amount of money, purportedly, which they probably didn't pay, and which probably nobody's going to chase after them. But they can in 2018, starting in 2018, they filed a petition challenging the rules basically of the NSCC, and one rule in particular was a deposit rule, and there were some other rules. And so they filed a petition, and they also filed later a motion to stay the proceedings. so that there could be no further action involving the proceedings until there was an outcome on the petition. So that happened in 2018. In 2019, the end of 2019, the petition that they made for the stay pending the outcome of the petition was denied. Briefs were filed on the petition. The final briefs were filed towards the end of 2020, and the SEC ruled on it November 6th, yesterday, 2023. So it took 5 years for this to go from a petition where some party was deemed a risk, because they were deemed a risk, a financial risk certainly. It took 5 years to get a answer, and the answer was, so the petition that was filed by Alpine challenging the rules of the NSCC was dismissed. So what's interesting is they challenged the rule under Section 19. This is not interesting, by the way, this part. They challenged the rule under 19D, I believe, of the Exchange Act. And under that act, they were challenging the specific, well, actually, the general rules of the NSCC, including the deposit rule and some other rules. And lo and behold, in 2020, a court in DC ruled on this very exact issue, and they ruled that these general rules couldn't be challenged in the manner that Alpine was challenging them, even though the case did not involve Alpine. But same exact setup, court ruled that in essence, Alpine couldn't challenge by petition that what they were doing. So a couple months after that decision, the NSCC changed their rules. So they got rid of this illiquidity deposit requirement, and the other claims that were raised by Alpine, either coincidentally or intentionally, were also changed in the amended rule. So this would have been 2020. And part of the discussion was prior to that time, prior to 2018, when Alpine made the stink about the NSCC rules, they had never complained. They never had complained in amendments. And this is apparently there's a doctrine in the administrative law field that you need to object at all stages to the rule changes in order to protect your claims. And here they did not, although they didn't object at all. So that was one aspect, that there was a court that decided, but then there was rule changes that literally addressed all of the issues. So that happened the end of 2020. And the end of 2023, the SEC issues its ruling, which was yesterday. And in the ruling, they basically say that the petition's moot because, one, the court said this was not a proper way of dealing with it, and two, because of the rule changes, substantively, there was no need to litigate those issues anymore because they weren't around anymore. And also, I believe that Alpine may have received some type of rebate for monies that were collected. So I found that pretty interesting in light of the ruling and the timing of the ruling. I thought the timing of the ruling was more interesting than the ruling because obviously it's a positive, another knock on Alpine's armor, but it doesn't specifically involve the expulsion side. So it has limited value in terms of that side. But on the other side, the order itself and the fact that they were deemed a risk when placed in connection with all the other evidence could be used by the SEC and FINRA in federal court to obtain some type of a receiver or similar remedy to get Alpine put out of business. And again, that would be independent of any of these proceedings, of any enforcement proceedings, of any expulsion proceedings. It would end, for all intents and purposes, that would be the end. And all this other stuff that's going along would be irrelevant to a large degree. So the ruling was, getting back to the ruling on the petition related to the national Securities Clearing Corporation, which doesn't involve expulsion and doesn't involve the appeal, which are really the issues that we are dealing with. I still expect Alpine to appeal to either, I expect them to appeal to a federal court because this was a ruling of the SEC. And I'm sure they will claim many of the things that they've claimed elsewhere. Um, I would expect that they will do it because they've seemed to, every time there's an opportunity to litigate something, they have. So I would expect them to litigate it. But I don't think this particular matter, other than the ruling itself and the inferences you can draw from the ruling itself, really are that important to Alpine's involvement with GTII. I think the other appeal, the other proceedings to expel on the FINRA SEC side are the important stuff. This is interesting, mildly helpful if utilized by FINRA and the SEC, but not, again, directly related to the expulsion, the real remedies we want. So again, it can be used in a federal court proceeding. The order itself, the findings can be used in a federal court proceeding, and the evidence of it can be used in a federal court proceeding to put a receiver in. I know there was and that's an available remedy. And in the interim, I think I would expect Alpine at some point to file an appeal. So I referenced it earlier, and now I'm going to address it. So the substance itself is not that interesting, but the timing really is interesting to me because it was continued. The decision was continued a number of times, and no decision was issued until after FINRA and all the amicus, the friends of the court, filed their briefs in the Alpine FINRA case. So the last of those friends of the court brief that supported FINRA's position were filed on the 3rd of November. This decision came out on the 6th. So it occurred to me maybe there's a connection. Perhaps they think it supports their position, the position of the government in the ongoing case. Perhaps they like the position of FINRA after seeing all the briefs, and maybe there's nothing connected. But I thought the timing was interesting, and I thought there may be a connection. So, in summary, again, this involves the National Securities Clearing Corporation. So the rules were upheld. I presume, and maybe falsely, but I presume, since a lot of time has passed, that should Alpine need other clearing houses, they could find them. They could find other means of clearing securities, even if it's through other parties. But it could make it more difficult for them. But other than that, this is National Securities Clearing Corporation. Alpine didn't escape the deposit requirements, but those deposit requirements were changed and reduced, and it's kind of like most of those issues are moot, other than the fact that Alpine was cited as being a scumbag, and they were a big credit risk, and that's about it. So that's how I deem it, and I deem the timing of the SEC's ruling maybe more significant than anything else, because that might reflect the fact that they liked what was happening in the briefs, and that would have been FINRA versus Alpine. And if FINRA wins that case, even though it wasn't final, it would be another nail in the coffin of Alpine, in my opinion. And again, just a matter of time. So we'll have to wait and see. I'll keep you apprised, obviously, if there's an appeal filed of this. And obviously, I'll keep you apprised of the ongoing appeal involving between FINRA and Alpine and all related things. Anyway, be well. Hope that made sense. Take care. If you have questions, please put them in the comments, and I will try to answer them if anything's unclear. And I can't imagine anything is unclear because I don't understand most of the stuff when I look at it the first time too. So anyway, be well. Take care. Have a good day.